Welcome to another installment of A Prosecutor's Perspective. My name is John Fleming and I'm a prosecutor in the Nacogdoches County Attorney's Office. This program is intended to provide information to the public about the duties and responsibilities of the County Attorney's Office, including general discussions of laws that the office is duty-bound to prosecute. We hope through this effort that the viewing public will learn more about its prosecuting attorneys, what they think, what they do, and we hope that this program will enhance the public's understanding of the role of a prosecutor in local law enforcement. This public venue allows for more detailed discussions of what happens in our office. There are fewer limits on time and space in this venue. It allows for more detailed conversations and hopefully a more complete understanding of the nature of prosecution. It is our hope that we can introduce various partners in the community who work closely with prosecutors, whether it be peace officers, probation officers, advocates who assist victims of crime, or mental health providers. We hope we can be a voice to help educate the public on the role of a prosecutor. None of the opinions expressed on this show are intended to be or replace legal advice. You should consult an attorney of your choosing if you have or think you have a legal problem. Thank you for joining us today for another segment of Prosecutor's Perspective. Today we're going to be discussing some of the new laws that were passed by the 84th Legislature here in the state of Texas. So many of the laws go into effect September 1st of 2015 and others go into effect January 1st of 2016 and still others even later in the year in 2016. Joining me today to discuss some of these new laws is Prosecutor Stephanie Stevens. Stephanie, thank you for joining me today.
Oh, I'm glad to be here, John. John, you know, our legislature meets every 2 years in Austin, and literally thousands of bills are filed every time they meet. The good news is they don't all pass. It's really a complicated procedure. Once the bill is filed by a legislator, it's referred to a committee, and whoever the chair of that committee is holds hearings on the bill. If they choose to, they may decide never to hear a bill. If it comes out of committee, it then goes on to the general session. And anyway, we're left with what actually came through and became laws this session. And of the bills that were passed, not all of those are things that we deal with as prosecutors, but some of them are. Some of the things that we want to talk about today are criminal law changes that impact things like invasion of privacy, assaultive offenses, crimes against property, and drug offenses. So why are new laws passed? Some of these are completely new laws. They address topics that haven't been addressed before. They're brand new stuff. And I'm going to talk about one of those in a minute. And then some of them change or amend laws that are already in effect. Both of these, whether they're new laws or whether they're changes to existing laws, generally are a reaction to something. They are a response to a problem that's either real or perceived, and sometimes they're even in response to a decision that's been handed down by our appellate courts. Some of them are just a response to changing time, like changing technology, and we're going to talk about that some today too.
Absolutely, and Stephanie, when you're talking about new laws, while all of these new laws, when they come into effect, impact the public, in particular they impact prosecutors and law enforcement as they relate to criminal laws. You and I today will be discussing laws that are found in the Penal Code, the Code of Criminal Procedure, the Health and Safety Code. I know that part of the reason that prosecutors and law enforcement need to know these laws is so that they can enforce them in the way that they were intended. And so you and I and other prosecutors in our office and other law enforcement personnel have been attending legislative updates. And those legislative updates are held all around the state, and that puts prosecutors in a position to know about the laws before they actually go into place. Prosecutors have played an important role in the formulation of many of these laws.
State representatives, state senators will frequently call upon prosecutors, oftentimes judges, defense attorneys in many cases, local police, sheriff, troopers, and ask them about how laws are going. Is this law being used? Is it a law that needs to continue to be on the books? Is it accomplishing what it was intended to accomplish? Our office, you in particular, Stephanie, have testified at different legislative sessions over the years. I know that more recently, a couple of legislative sessions ago, our office was asked to testify in connection with a cockfighting ring that was busted here locally. And in connection with trying to prosecute that particular illegal ring, we found that it was very challenging to prosecute the spectators. In fact, we could not prosecute the spectators. What was interesting that we found out is that when individuals attend a dog fighting contest, which is illegal in the state of Texas, the spectators, in addition to those running the ring, but the spectators themselves were committing an illegal act. But when spectators were watching a cockfight in process, where the roosters are fighting one another, that was not illegal. So we participated in calling to the attention of the legislature what appeared to be a loophole that needed to be closed. And it took a couple of legislative sessions, and sometimes it takes more than one because it can be a very arduous process.
It can. And John, there are other laws that have changed in recent years that have been a reaction to appellate court decisions, and not just our local appellate courts. One that comes to my mind is once the United States Supreme Court said that we could no longer sentence a juvenile offender who had been certified to stand trial as an adult and convicted of capital murder to life without parole without giving a jury other options. At that point, we had to go back. Not only did we have to change our statutes here in Texas, but we had to go back and fix the problem of all the juvenile defendants we had that were currently serving life without parole. So that's just another way that our legislature changes laws.
Exactly. And so a lot of the laws that we see are passed, just like you said earlier, Stephanie, they might be in response to a new circumstance within our communities, within our culture, or they simply could be correcting a law that doesn't look like it's operating the way it intended. Or, in the case that you just described, where we have the Court of Criminal Appeals making a decision that makes our law unenforceable in some way, and we have to deal with those ramifications. But getting to some of the new laws that came down in the 84th legislative session, there were some interesting laws that go into effect September 1st, 2015. Stephanie, what were some laws that really struck you as being significant out of the 84th legislature?
Well, the new law that I think is probably most significant was what we call revenge porn. And it addresses a situation where someone has consensually allowed someone to take photographs of them, intimate photographs of some sort, and now that relationship is over, and suddenly those photographs are being spread across the internet, or even somebody's making a threat to broadcast those. That behavior is now a Class A misdemeanor. Wow. And what's interesting is that we're talking about photographs that someone agreed to at the time. I call it kind of the Tonya Harding law, because we all remember those videos back then. But it's that sort of situation where two consenting adults have agreed to take these photographs, and now, for whatever reason, one of the people wants to share these photographs on a website or transmit them to other people, broadcast them in some way. What's also very interesting to me, not just that the revenge porn situation, is that if you threaten to do this, if you say, hey, I've got these dirty pictures of you, and I'm going to put these on Facebook unless you pay me money, do what I want you to. Basically, you try to extort someone in some way. that too is a Class A misdemeanor. And we've talked about before that Class A misdemeanors are punishable by up to a year in jail and up to a $4,000 fine. So this is pretty serious business we're talking about.
And Stephanie, just along those lines, and we've both been involved in private practice over the years, but a lot of times when we see examples of revenge porn, or when we see someone in a relationship who's disgruntled, they will use something as a weapon, such as an intimate picture. And a lot of the examples, I think, that were raised with the legislature to try to secure enough votes to pass this new law related to relationships that had gone off the rails. Would you agree with that?
Absolutely. I would say 99% of these instances that you hear, that you read, that you see about are a relationship gone sour. And, you know, I guess sometimes people don't think when you think you are in a relationship with someone, you don't think about what's going to happen if this ends, which is natural. I don't think people focus on that. But then relationships do sometimes end, and gosh, people can be very bitter. But when you talked about being in private practice, what's also interesting about this bill that made this a law is that it also creates a civil cause of action. So you can actually sue someone now for doing this and recover damages. And you know, imagine what sort of damages somebody might have, even just for emotional distress, if nude photographs of you that you thought were private between you and another individual are suddenly posted on Facebook or posted on some other website. Then, you know, imagine the cost to try to get all of this, clean this off the internet.
So this particular illegal act, there's a criminal component. It's against the law. It violates the penal code.
That's what we deal with, is the, right.
But also, that individual could sue someone for money damages.
Absolutely.
And as I recall, Stephanie, within this aspect of the law, a person is allowed to sue specifically for mental anguish. That's something
right.
that the legislature recognized, that one of the most significant consequences of being a victim of this kind of crime is emotional distress, probably what was intended by the perpetrator of the crime, trying to embarrass, trying to humiliate, inviting the public into what was otherwise a very intimate, private moment. But the legislature dealt with some other laws with respect to invasion of privacy. Is that correct?
They did, John. They kind of reformulated an old law that was called improper photography and made it now invasive visual recording. And it's what we kind of refer to as the upskirt down blouse law. What it says is that you can't take photographs of people's intimate areas in a public setting if you're doing this to invade another person's privacy. And the history behind this law is kind of interesting because the way the law was originally written when it was the improper photography law, it focused more on the intent of the photographer to arouse or gratify their own sexual desire. So that was one of the elements that a prosecutor had to prove, that they took these photographs, whether it be in a public setting or not, and it was designed to address things like, gosh, sometimes we hear horrible stories about people who've set up recording devices in a public restroom or in a changing room or someplace like that. And that's what it was intended originally to address. What happened was that it was used a little bit more broadly than that. And if I recall, the case that the Court of Criminal Appeals looked at was a case involving a photographer taking pictures of cheerleaders at a sporting event who, you know, sometimes the cheerleaders are wearing very short skirts, and it is a public setting, but they felt like this person was taking them with the intent to arouse or gratify their own sexual desires instead of for whatever, you know, because this is their daughter, their niece, whoever the person is that they're photographing. The Court of Criminal Appeals said, you've got a First Amendment problem here because these people are in a public place and this person does have a First Amendment right to take these photographs. So that's why the legislature came back and said, okay, we get that. So now what we're saying is, yeah, you may have a First Amendment right to do these even if it was for this reason, but you don't have a First Amendment right to invade another person's privacy. And if that's your intent, then no, that's against the law. And it deals with situations which I've never seen, but I've always heard of people who are, holding a cell phone down, trying to take a picture up a young lady's skirt, or trying to take pictures down a woman's blouse or something. And, it deals with, even though it's a public setting, taking photographs of what would normally be considered intimate parts of someone's body, even if the parts of their body are clothed.
So even someone in a public place.
Absolutely.
Exactly. And what is the penalty?
That's a state jail felony. And so that's something you can go to the state jail for up to 2 years or be fined up to $10,000 for that.
And Stephanie, one of the reasons why we're seeing activity with respect to invasion of privacy laws really is a function of the age that we live in.
Yes.
It's a combination of all of us, at least in my opinion, having camera capabilities on our cell phones, and then that dovetailing with the internet. Where years ago, and we've talked about this before, with Polaroid pictures, it would take quite a bit for a picture to circulate around a school or around a fraternity house or wherever it may be. But now, with the advent of the internet, literally hundreds of thousands of people could have access to an image, an intimate image, just within a matter of moments of uploading a picture to a particular website.
Absolutely, and that's where the damage becomes so frightening when we're talking about the revenge porn, that emotional distress to know that this picture didn't just, make it around the school, it made it around the world.
Yes. So we think that it's good and appropriate that the legislature made some significant decisions, and we're grateful, at least as prosecutors, that steps were taken. But they took steps in other directions, and one of the steps that they took, Stephanie, was adding some provisions to human trafficking in connection with continuous activities. And just real quickly, the first time that I saw a law that involved continuous acts was in the domestic violence arena.
Yes.
And the situation was like this. We had typically we would have a victim of domestic violence who, say, for example, was assaulted on January 1st of 2014. The individual is arrested on January 1st of 2014, but doesn't have a court date until August of 2014. So February, March, April, May, June, July, all of those months we have an individual who isn't being held accountable for that original action. So what the legislature did, and I think that, again, it's a response to a problem, but I think an appropriate response, is that they made it a felony level offense for there to be a second act of assault family violence while the defendant or suspect was waiting for trial. So if now that we have this continuous family violence law, you have someone who is assaulted January 1st, 2014, which is a Class A misdemeanor, as we know and we've discussed. And then March 1st of 2014, we have another Class A family violence misdemeanor committed against the victim. What was, in the past, 2 misdemeanor cases has now become a fairly significant high-level felony. That's not new law, but we have seen variations of that in some other areas of the law, and can you speak to that?
Sure, human trafficking. Human trafficking is huge in the legislature this year, as it was the last session also. It's very interesting to me because here in this part of Texas, we rarely, if ever, see human trafficking cases. In fact, we were recently at a legislative update, and someone asked, how many of y'all have ever prosecuted a a human trafficking case, and literally no one raised their hand. I suspect that down around the border, on some of our major thoroughfares in Texas, it's more of a problem. And what the legislature did was made it a crime to engage in what they defined as continuous human trafficking, which means two separate acts on separate days, 10 or more days apart. And it's kind of a different definition than what you were talking about with continuous family violence. So if you have somebody who's engaged in human trafficking, they're smuggling people for whatever their purpose is on day 1, and then on day 11, there's another transaction of them doing the same thing. That's now a new offense with additional penalties.
And really what the legislature is doing is trying to increase this penalty for this conduct that is repetitious, something like
Sure,
that. But
sure.
also, Stephanie, fortunately, the legislature also spoke to some other domestic violence issues, and can you speak to that?
They did. They made an interesting change in our penal code, which says that evidence of the relationship between the parties, the abuser and the victim, is now admissible during the guilt-innocence phase of the trial.
Why is that significant?
Well, it's significant because a lot of times under our rules of evidence, that was not admissible. So what a jury is seeing is one instance of violence. And John, as you and I both know, seldom is there just one instance of violence. This is something that's come to a head between these people, or this is a situation where you have a victim who's finally gotten the nerve up to call the police, to get law enforcement involved. And when you shut it all down and just show this snapshot of this one episode, you don't get the full picture of what's going on here.
The jury might think that there's been only one incident, and that's the one that is being discussed.
The jury may think, well, she's upset because this time he lost his temper. And I use women as victim and men as the aggressor because most of our cases are that way. They're certainly not all that way. I don't mean to sound sexist. But yeah, and they may not understand that this is something that's been ongoing. This isn't, he snapped because she lost the remote batteries. It's a whole progression of, well, last week he assaulted her because he didn't like what she made for dinner. And then the next day he assaulted her because she didn't tell him she was leaving to run errands. And they see what the true relationship is. This has been our law in other circumstances. For example, when we're talking about murders, it's long been the law that at the guilt-innocence phase of the trial, the relationship between the parties is admissible. This is a new tool that we have. It's untested. We're not 100% sure how the appellate courts are going to like it, but hopefully it's a good law and we're going to benefit from its passage.
Absolutely. Stephanie, the legislature, what we've talked about so far are crimes involving invasion of privacy, and offenses against persons, but there's an entire part of the penal code that is dedicated to offenses against property, such as theft. And we saw some real changes in our theft statute, something that we haven't probably seen in 20 years, to the value ladder. Yes. And to the extent that we can pull up a chart, we can see by looking at the chart that Class C misdemeanors, for example, all the way through first-degree felonies, there's an old law column and a new law column, and the values have changed. And it's interesting because for example, Stephanie, Class C misdemeanors, it once was that if someone was accused of stealing something of a value of anything over zero up to $50, it was a Class C misdemeanor. What the legislature has done is change that value ladder, for example, on Class C, and moved it up to $100. So before September 1st of 2015, if someone were accused of stealing something that had a value of $75, it would have been a Class B misdemeanor, because with a Class B misdemeanor under the old law, it was $50 to $500. Now, if someone is accused of stealing something that had a value of $75, that would be a Class C misdemeanor. And as we've discussed before, there's different penalties. For a Class C misdemeanor, there is no jail time. The jail time possibility starts with Class B misdemeanors. And as the value ladder reflects, this is affecting misdemeanors and felonies. Now we will be handling, interestingly enough, cases that would have been felony level. If someone is accused of stealing something over $1,500 but less than $2,500, it will now be a Class A misdemeanor. And my understanding, Stephanie, is that this is in response to inflation because the value ladder was established, I think, sometime in the early 90s, maybe around 1993, and had not been altered. I think someone might look at this and say, well, it looks like we're being easier on crime or something along those lines, but you would disagree with that. Is that correct?
I would, John, and one of the issues, one of the reasons is this inflation issue. You're correct. 1993 was the last time the value ladder was changed. And you talked about theft. This same value ladder applies to some other crimes like criminal mischief. But the last time it was changed was 1993. So if we're talking about 2015 dollars, yes, it looks like a big switch. But when we're comparing 1993 dollars to 2015 dollars, it's not such a huge change. There are also enhancements for repeat offenders who commit theft. If you commit a theft and you commit even a Class C theft, but you've got 2 prior theft convictions, regardless of what degree of offense they were, that's now a felony. So theft is something our legislature still takes very, very seriously. There are also consequences to continuous theft. You can consolidate some offenses in certain circumstances so that the person who's out there habitually shoplifting, all of a sudden that's bumped up to a higher degree. So it depends on how you look at it, but I don't think that we're really taking these offenses any less seriously. We're just adjusting them a little bit to fit the time.
And they've also simplified it, as you said, by adding it, making it across the board, so to speak, with criminal mischief and some of our other categories of crime. So it's really easier on prosecutors and on judges now having one value ladder for multiple different offenses. And I think from our perspective as prosecutors, Stephanie, if we get someone in our court who's accused of stealing something that has a value of close to $2,500, where it would have been a felony just not that long ago, but now would be a misdemeanor, we have vehicles available to us to have a stronger recommendation to the judge. We can have more community service hours. We can seek jail time as a condition of probation. So there's things that we can do as prosecutors to the extent that we think that maybe someone's taking advantage of it.
Sure, and John, I want to talk about a couple of other things real quickly. One are some changes to our health and safety code and substance abuse laws. The important thing to note is that nothing changed about marijuana. Marijuana is still, possession of a usable amount of marijuana, still against the law in Texas. The only thing that changed is that low THC cannabis oil is now legal, but this is not marijuana. So I don't want people to get confused when they see this. We're talking about people who have legitimate illnesses and are prescribed this low THC cannabis oil by a physician and go to a pharmacy, not some local pot shop, to get it. That is now legal for its medicinal purposes, not for any other purposes.
And Stephanie, I think that we both received what amounted to a small or medium-sized book with all of the law changes, and it's very difficult to discuss, even scratch the surface in 30 minutes. But what I'm thinking we can do is maybe have a second discussion of new laws where we'll discuss synthetic drugs, among other things.
Absolutely. We've just touched the tip of the iceberg. We've got a lot more to say next time.
Thank you for joining us, Stephanie.
You bet.